qualifying for benefits. The first one I'm introducing is Pilar Gonzalez, who works for Disability Rights California, formerly referred to as Protection and Advocacy, and they're in all 50 states. And she's going to speak to qualifying for California Regional Center benefits as an adult, and their process, and what do you do if they deny the application, in other words, the appeal. Okay, Pilar?
Hi, everyone. Thank you. First of all, thank you for having me. I've been learning a lot as I've heard the COPR Centers, so I'm really thankful to be here today. So I'm just going to go really quickly over an outline of my presentation. I'll talk very briefly about what is the Office of Clients' Rights Advocacy to give you some context on what our office does, because we specifically serve regional center clients. Then the regional center system and what services are available through the regional center system. I will also talk about how to become eligible for regional center services, what the requirements are, and the application process. And lastly, very, very briefly, I will talk about the regional center eligibility appeal. So the Office of Clients' Rights Advocacy, OCRA, is part of Disability Rights California. We are the protection and advocacy agency for the state of California. And OCRA is one program within that agency. We represent specifically regional center consumers or people that are applying for regional center services. And the most important thing that I tell families is we are not part of the regional center. We are completely independent from them. Our contract is with the Department of Developmental Services, so DDS funds us. We provide free legal advocacy services in various areas of the law, of course, about regional center services, but also about any types of benefits, such as IHSS, Medi-Cal, Medicare, Social Security, Children's, California Children's Services, and also special education as well as other areas. So the regional center system, they are basically the entities that provide services for the consumers. They don't directly provide the services. They are the agency that contracts with the vendors that will provide the services to consumers. And they were established through the Lanterman Act, which is a California statute that is part of the Welfare and Institutions Code. The Lanterman Act is intended to give people with developmental disabilities the right to services and supports that would allow individuals to live more normal and independent lives. And then throughout my presentation, anytime that in parentheses it says W and I is the Welfare and Institutions Code. So services and supports. The purpose of services and supports through the Lanterman Act is to lessen the effects of the developmental disability. So any services that the person asks, it has to be related to that disability. And to allow people, again, to have a normal, independent, and productive life, and to learn new skills. The categories of services, and feel free to ask questions at the end about any of these categories. I'm just going to go through them pretty quickly. One, assessment services, habilitation and training, treatment and therapy, preventive services, living arrangements. So that could be, supported living services. It could be independent living services at parents' home. It could also be specialized group homes. Community integration services, those are services that help the person remain in the community and live more integrated with other people that do not have developmental disabilities. Employment and day programs, some of the COPR centers have mentioned some programs before, so the regional center vendors specifically with programs that specialize in providing training to people with developmental disabilities. Family support services, relationship services, so that could be, therapy for, how to have, how to have relationships with people, not be taken advantage of. It's a pretty broad service that can be provided. Emergency and crisis intervention, that would be something like CBAM, which is through the regional center system, and there's similar agencies throughout the state. Specialized equipment, transportation services, that can be to work, to a day program. It wouldn't be to school because that would go through the school system. Facilitation services, self-advocacy. I've had clients that have the regional center fund, trips to go to self-advocacy conferences in Sacramento. And then just general advocacy services. So how do people secure services through the regional center? It is done through the individual program plan, or IPP. This is very similar to, in the special education context, the IEP. And it is the process to secure services. It is a contract between the regional center and the consumer. It must list all of the services that are being provided, and it must be person-centered. What does that mean? That the services should be individualized and tailored to each specific consumer. So the whole list of services that I provided before, it doesn't mean that every consumer is going to get each of those services, but that they should be getting the ones that they need to live more normal and independent lives. It is the regional center's responsibility to ensure that all needed services are being provided. So although the regional center does not provide the services themselves, they contract with providers. And so they have to make sure that they have enough providers to give those services to the consumers. All right, so now I think this is a part that everybody really wants to talk about, which is regional center eligibility. So there are 5 categories that make you eligible for regional center services. I'm going to focus on autism, but just to give you the context, I'll go through each of them. First is autism, epilepsy, cerebral palsy, mental retardation, which is now intellectual disability, or a condition similar to or requiring similar treatment to mental retardation. That is commonly known as 5th category. It's for people whose IQ levels is too high to qualify under intellectual disability, but their treatment requires services similar to that of an intellectual disability. The second part, so if you have one of those diagnoses, you still have to meet the other 4 requirements. One is that it must originate prior to the age of 18. The important takeaway from this is even if the person is over 18 years of age, they can still qualify. All that they have to show is that their disability originated before the age of 18. Are we taking questions right now or at the end? Sorry, I just saw a hand.
I just had a quick question.
Sure.
As far as, what if you don't have any proof before age 18, but you have cerebral palsy? Is that enough proof?
The answer is yes, because cerebral palsy has an onset. Oh, I'm asked to repeat the question. If someone has CP, cerebral palsy, and they're applying as, I guess, an older person, by medical definition, cerebral palsy happens right before, during, or right after birth, the deprivation of oxygen. So I don't see that would be any problem. Thank you.
So I would say, if the person is the person is over 18 years of age, and they didn't have a diagnosis before the age of 18, you can run into some problems. I generally recommend that families look at if the person went through special education, that they bring those records to the regional center. They can also get, a new doctor diagnosis, and where the doctor explains, this is a condition that happened before the age of 18. It went undiagnosed for whatever reasons. So, it was good to hear from medical professionals here, because we rely very heavily on them when applying for regional center services. You could also bring, in terms of autism specifically, therapy records. If the person ever went to ABA, that would be something that would tend to show that they had autism even before they were diagnosed or before they turn 18. Any medical records of services secure either through private insurance or through Medi-Cal. So those are some of the ways to overcome. Most of the time, it is going to come down to, having a doctor that can say this originated before the age of 18. That is going to be the strongest evidence, really. And with autism, thankfully, due to conferences such as this and people just be more aware of it, we are seeing more and more that regional centers don't argue with saying, oh, he didn't have autism until he was 35. It's just there isn't a lot of medical proof that autism would just start at 35 and not before. And then the other areas that must be met, the other requirements, is that not only does the person have to have autism, the condition has to be substantially disabling, and in the next slide I'll explain what that means. Expected to last indefinitely, and it cannot be solely physical, solely learning disability, or solely psychiatric. When I get clients that have that come and have a diagnosis of ADHD or a specific learning disability, I'm always careful to tell them to apply. I say, just having those specific diagnoses would actually disqualify you from regional center services. You can have ADHD or a special learning disability and autism, but if you only have those diagnoses, it's very likely that the regional center is going to turn you down. So what does substantially disabling mean? It means that the person has significant functional limitations in 3 or more of the following areas. And those areas are self-care, receptive and expressive language, learning, mobility, self-direction, capacity for independent living, and economic self-sufficiency. If a person, I often have parents that come and say, well, my child has autism, but they're very high functioning. I don't think that they're going to qualify. They got great grades in school. Well, that doesn't necessarily mean just because somebody's high functioning that they're not going to qualify. An adult could have, gone to college and be very, quote unquote, smart, but they have issues with self-care because of some of the symptoms that prior presenters have talked about, right? If they need to wash their hands 50 times before they get out of the house, anytime that they touch a doorknob, I would say that, that substantially limits, your self-care, your ability to live independently. Also, it could affect economic self-sufficiency. For adults, I would say that the more important categories would be showing capacity for independent living. Of course, as a child, that's, no child can really be independent in their living arrangements. But as an adult, if they still live at home, if they need constant supervision while at their home, even if they have their own apartment, that could be a functional limitation. As well as, for autism, it could also be receptive and expressive language. Okay, so the application process, it's actually pretty easy to apply for regional center services. You have to contact the regional center. Each of them is different, but most of them have a phone number and also a form that you can fill out and fax, or in some cases email. Those forms are really about 1 page long. And then the regional center determines if assessments are needed. So you might come in and have all of your assessments and have a lot of special education records, diagnosis from doctors, but the regional center could still say, well, we need our specialists to assess them. Those assessments are usually, they meet with the psychologist from the regional center, maybe a social worker. They do an interview process. And then, the regional center must complete that assessment. For this whole entire process, the regional center has 120 days from the time that you applied to complete the assessments. There is an exception, which is 60 days, if the 120 days could cause delays in development, health, or a more restrictive placement. So for example, if somebody has been recently diagnosed with autism because there's been an upsurge in behaviors, and this person has been living at home with their parents are at a point where he's having so many behaviors, they don't know if he can stay because it's placing other children at risk or placing the parents at risk. I would say you could argue that that person is in danger of being in a more restrictive environment, and requires the assessments to be done within 60 days. Okay, and then lastly, very, very briefly, the regional center eligibility appeal. So the regional center must provide you a written notice of action and stating whether or not you're eligible for regional center services. So within those 120 days, you need to get a letter back saying whether you are eligible or not for services. If you're not eligible for services, it should state the reason why. So it might say, because your disability is solely physical and a learning disability. If you apply just with, a diagnosis of a specific learning disability. Or it could say, because you're not significant, there's no significant delays in 3 areas. So it's, that notice is gonna be the starting point for you to know what might be the missing information that you need to get for your appeal. You have 30 days of appeal. If you do not receive a notice, then those 30 days don't start running, or if the notice is not appropriate, the 30 days wouldn't apply either. And then you can also reapply it instead of appealing. I think that's a really important thing to note. If you appeal the decision and you go to hearing before an administrative law judge and you lose that appeal, you cannot apply for regional center services again. The only way to do it is going through the civil court system. It's extremely difficult, to overturn the ALJ decision. So what we tell families often is go back, gather more evidence, and look at the notice. What did it say? Get the extra records, get more letters of support, and then reapply again. You can reapply as many times as you want. Don't reapply 1 month after another without new information, because the regional center is just going to keep turning you down. But you can always reapply instead of appealing. Okay. And a quick closing note, this was a very quick overview of a complex system and a complex process. So, feel free to call us. All of our services are free. And we can provide, counsel and advice. We can review your notices and records. We can provide you with publications that have legal information. We also have, which I think it's really helpful for families, sample letters for doctors and specialists. So it's a letter that you can give to your doctor and say, I'm applying for regional center services. In your diagnosis or in the report that you write, could you, review this letter beforehand to make sure that includes the legal information? And when I work with doctors, I give them that letter all the time. And we also have referral lists. If you're having trouble, getting a diagnosis, we have referral lists for specialists for regional center services. And then lastly, I put our number for our office. But that's it.
One question, Ms.
Yes.
Gonzalez. How much time is there to file a lawsuit in district court for those people who've been denied initially and again on an appeal?
I believe it's a year, but I would have to check that. I think it's a year.
Okay.
Yeah.
Thank you.
Yeah.
There's a,
I want to be mindful of the other presenters, so I'm not sure if we're doing questions now or after.
I just
We
have
can
a
do
quick
one? Okay.
question. What is significant? How do you define that?
So that's a great question, and I will say I rely on doctors to say that. So,
Because, we have different,
did you use the microphone?
because some of our stuff.
Go to mild, moderate, marked, severe, but then where does significant go in
I
there?
would say, things that
That's what we're used
affect
to.
a person's capacity to do those different things. So, like I said, if somebody, because of their disability, continually needs to wash their hands 50 times before they leave the house, after they touch anything, that's significantly affecting their life. But again, I would say a lot of times we as attorneys can say what the requirements are. The medical component, we do rely a lot on doctors. And I think sharing that specific language with doctors so they can put it in their reports, the specific wording of the statute helps the regional center when they're seeing those keywords. So instead of saying, like Dr. Val, instead of putting moderate, could you say, is this significant or not significant? Those would be conversations that I would have if I took on an eligibility case.
I think it's similar to the Americans with Disabilities Act, which uses the word significant. We're going to go over that standard briefly, but shortly.
Okay, thank you.
It's more similar to that than those Social Security categories.
It's a term of art, I guess.
Right.
Thank you.
Thank you, Ms. Gonzalez. Next, we have Tim Carter, who works at our office, People with Disabilities Foundation. He's a Social Security attorney who's going to go over those situations where someone perhaps doesn't qualify for regional center funding, and this could happen lots of different ways. It could be a legal error, it could be a decision not based on substantial evidence, and sometimes it is necessary to go to court. It could be someone who has Asperger's or is high functioning, not enough really to live and work independently. So you do see consumers living in board and care homes and working in sheltered type workshops where they have a lot more assistance and supports than they would in competitive employments. And they end up being on SSI. And so SSI is really important. It doesn't pay as much as through the regional center. And also, people can be eligible for SSI as children if they're so severely disabled that they live in an institution. That way, their parents' income and resources will not be deemed to them, and the SSI check would go to the institution as just another resource. Let me say this, overall, when a child, whether a newborn or not, is very severely disabled, it's going to be a financial burden on a lot of families. And what often happens, but it's not always the scenario, is either the school district is going to pay or the regional center. In other words, in the Rehabilitation Act of 1973, I'm talking about Section 504 of the statute, a free and appropriate education is required to be provided by the school district. And there are times, unfortunately it's all too common, when the school district does not want to pay. They find technical grounds like it's going to be private education the whole time, and there's litigation over this. And the parents who are denied by both are going to, in most part or large part, go to court in a situation like this. Court is a real appeal as opposed to reapplying administratively and hoping to get a different decision, especially for a family who's been denied by the regional center and also by the school district, at least during those years up through age 18 or the 12th grade, or it could be a few years past age 18. So today we wanted to cover what Ms. Gonzalez did, applying through the regional center, because there's a lot more funding per person than there would be from SSI or Title II, which is Social Security Disability Insurance, and for certainly disabled adult children. So there's only one other thing I want to mention before I turn the mic over to Tim Carter, and that is, and it's not part of today's thing, but the Americans with Disabilities Act protects individuals who have a significant disability, which is defined as in a major life activity such as walking, talking, thinking, etc. And in employment, just to use an example, the individual would have to be able to do the essential job duties of any particular job with or without reasonable accommodation. So be aware the word disability has different definitions if it's under the Social Security Act, under the regional center definition, under workers' comp. There are different definitions of disability, and it's just important to be aware of that. Okay, Tim, did you want to start?
All right. So I'll just be going over some of the disability programs briefly that are run by the Social Security Administration. This is general information purposes only. It's not legal advice. There's not, for a particular person, there's not enough time to give anybody enough information that they would need. This is, hopefully this will help you know, give you more information to know about when to seek more information, either do more research or see an attorney yourself. So the Social Security Administration runs two different disability programs, and they have different rules. Their medical and vocational definitions of disability are the same, but their other rules are completely different. One of the programs is supplemental security income, the SSI that we've been talking about. That's a welfare program for people with low income and resources. And so what matters is that you're disabled and you are in poverty under their definition. The other program is the Social Security Disability Insurance, and that's the program that you are entitled to from paying your FICA taxes. That pays for your retirement and the disability insurance program. Supplemental security income comes with Medi-Cal. People who are eligible for SSI are eligible for Medi-Cal. The Social Security Disability Insurance comes with Medicare after like 24 months of eligibility. A beneficiary can end up being on both programs, and if they are, they end up getting double notices for a lot of different things, each one being 8 or 9 pages, and talking about the different rules, and it can be very complicated for people. Okay, so let me talk a little bit about both minors and adults so that we can talk about the transition. For minors, there are The two components for being eligible for SSI are being medically disabled, and they have to meet the income and eligibility requirements. And for adults, there's the third component of vocational, of what they're able to, what kind of work they're actually able to do, or if they're able to do work. Who qualifies for SSI as a child? You can qualify either by meeting or equaling a specific listing. And for children, if they don't meet or equal listing, they can they have 6 different functional domains that they can that they can qualify for by either being severely or multiple moderately impaired in these areas. Don't have time to really go through those. The listing for autism, autistic disorder, and other pervasive developmental disorders for children, that's listing 112.10. For adults, to be eligible, they need to either meet or equal a specific listing, and the adult listings are 1 through 14. Or they must show that they are unable to do any work, and by any work that can be anything. Anything on a sustained full-time basis. If they can do anything if it's minimum wage, very simple work, then they're not disabled. For adults, the listing for autism and other pervasive developmental disorders is 1210. And generally, if you, well, I'll get to that. Let's see. Okay, for SSI, the income and financial resources cannot exceed specified amounts. Types of income and resources that don't count, there's a long list, but some of them that we put here. Typical, if you own a home, that does not count against you in terms of your resources. I had an SSI client once who was quite close to being a millionaire simply because they had bought a home in San Francisco back in the 60s. Or, well, not in the 60s, but about 20 years ago. The household goods and personal effects don't count. One vehicle, however much it costs, doesn't count. A third of the income received for child support from an absent parent. Foster care payments, some types of pensions don't count. Up to $100,000 in a qualified ABLE account. Funds for a plan to achieve self-sufficiency. That's a program that Social Security can approve to help you if you want to start your own business or train to be an employee. Grant scholarships and gifts and tuition for educational fees and expenses are excluded for 9 months. Okay, when you're receiving SSI, they count against you the unearned income on with a $20 exclusion. They then count against you every dollar that you get. They subtract it from your SSI. Unearned income is income from any source that is not earned. So, for example, gifts and inheritances are unearned income. In-kind support and maintenance, and I think I'll discuss that a little bit more, will count as unearned income. And the SSDI benefits that people receive. So if people are receiving SSDI benefits that are under the SSI amount, that's how they can end up on both programs. The ABLE accounts are new accounts set up that are authorized by Congress, and the Congress has authorized states to create the ABLE accounts, and they work as a way of sheltering money. It'll shelter them for some tax purposes, to be used for your expenses related to your disability, and that's the California. Their ABLE accounts are going into effect in January, and for the first 100,000, for purposes of SSI, what's important is that the first $100,000 in the account balances are not countable resources, but they have to be used for disability purposes. And then even if you're suspended because of your ABLE account balance, the beneficiary could still receive Medicaid, which is known as Medi-Cal here in California. SSI application process. You can call SSI, the Social Security Administration, to make an appointment. Calling protects the filing date. You are eligible for benefits as of when you file. I believe it's also possible you can do that online. You can bring information about your income and financial resources, such as earning records, bank account information, leases, and however you apply, you should do so in a way to make sure that you get a receipt of the time, and you get the papers, copies of the papers that show that you applied in order to protect your filing date. And Social Security often makes errors in determination. That's why there's an industry of claimants representatives. Social Security Administration monitors the income and resources, looking at the amount of benefits, which are recalculated monthly for the following month based on your income and what resources that you have. And they do periodic redeterminations of eligibility. They have what they're known as continuing disability reviews, depending upon the type of disability or the way they found you disabled. The continuing disability reviews can be required at 1, 3, 5, or 7-year intervals. They're supposed to determine whether or not there is medical improvement. And then if there has been improvement, if you still qualify as disabled, the burden of proof lies with the Social Security Administration to show improvement, but they often do make errors in determining that as well. And what's unfortunate here is that with continuing disability reviews, it's sometimes difficult for people going through the continuing disability reviews to get to find an attorney, because don't end up being back benefits that attorneys can take the fee out of, so it's harder to get representation. Yeah, well, harder to get representation from private attorneys. It's one of the things. If you're going through a CDR, you should probably look for a nonprofit legal aid representation. So people who are on, for children who are on SSI, when they turn 18, Social Security will do a redetermination at age 18, and what they then will do is, I mentioned, so there are the two different rules for children and for adults. So if they're on SSI as a child, they turn 18, they then redetermine them under the adult rules. If the child had qualified for SSI because they met a listing, they are probably at that point more likely to be to qualify as an adult, because the listings for children and adults parallel usually very well, and so if you met one, you're likely to meet the other. A child who qualified based on functional equivalency may have more work to do, because then they will have to show that they are unable to do any work. And again, that's any sort of minimum wage work that that's unskilled. So Social Security Administration will consider the following in making its decision regarding the ability to work. They'll look at how the child who's now turning 18 functions in educational programs, their community and work experience, and their work-related stress. And evidence that was used to establish under 18 can still prove disability in young adulthood because it's still relevant. We have evidence here for the age 18. A lot of this is also for not just at age 18, but for others. But most important is what the doctors say, that you need a doctor's diagnosis, and then other healthcare professionals, they don't get as much weight as a doctor, but they can be used to show how functional a person is, the severity of their impairment. At age 18, you can still look at school records to show how they functioned, and of course you can also use as evidence family and community members, and although quite frankly that really depends upon the judge. Usually it's helpful if the judge is already inclined in your favor. If not, the judge will probably just ignore what your family and friends say, unfortunately. So at age 18, the financial resources are based upon the child's income and resources, and the parent's income and resources are no longer deemed to them. If the parent is providing them with income and support and maintenance, it will reduce the amount of the SSI benefit. Students over age 18 may still be considered a child for SSI purposes if they're under age 22 and still going to school, college, or a training program. And for SSDI purposes, if you're disabled before age 31, then you have to, then there's a shorter period of time in which you needed to have been paying your FICA taxes. Let me skip to, Let me skip to this. SSDI on the account of another. Social Security Disability Insurance, I mentioned that program is the one for when you've paid in your FICA taxes and you're paying for insurance for your retirement pension and your insurance. You're also paying for insurance to insure your children if they're disabled. The entitlement amount are determined by the parents' earning records, just like any other time you go on SSDI disability, or when you retire, it's based upon your earnings record. Here, it's based upon the person who earned it, the parent. The person, you could be entitled as early as birth, and you can receive it after age 18. To receive the disabled child benefits, the disability must have occurred prior to age 22, and it must be continuous through the present, and the child must be working below what they call a substantial gainful activity amount. In 2016, that's $1,130 for most impairments, $1,820 for blindness. So one of the things that's important here is that for what we've been talking about is that you don't have to have started on the disability before age 22. You just have to show that the disability itself began age 22. You don't have to have been receiving benefits before then. And again, with autism, a developmental disability, the medical consensus is that it would have, by definition, had to have begun before age 22. I would plan, though, to have to prove that to a judge, bring in medical evidence of that scientific consensus, because some more conservative judges are not going to know that or accept it without evidence right in front of them. Advantages of receiving the DAC versus SSI. Usually the DAC benefit will be higher than SSI. There's no restriction on income or resources, and the DAC benefits are tied to Medicare. The disadvantages of DAC versus SSI. DAC benefits do not always provide Medi-Cal, but you can buy into it. And individuals on DAC, you can't get married and still receive DAC unless you're marrying somebody else who is a disabled adult child. And then finally, I'll just mention, won't go into it, we have the information in the handout, but SSI and SSDI have their own work incentive programs that are designed, designed from Congress. The intent is to help people get work and not be cut off immediately, to incentivize going out and working. Unfortunately, the SSI and SSDI incentive programs, the two different programs, they have different incentive programs with different rules, and so somebody who's on it's particularly a problem if they're on both, because then if they want to go out and get a job, they have to worry about both sets of rules, which are incredibly complicated and can end up disincentivizing work. I would suggest anybody who is on SSI or SSDI thinking about going out and getting work to talk to an attorney really as soon as they can about how they can best keep their benefits.
Oh, okay, yes, thank you, Tim Carter. Good job. We do have a few minutes now for questions for all panel members. I will mention from online, some came in, and Dr. Hendren, for this question, I mean, if you know, there are a couple of questions relating to autism and genetics. And the question is, are there studies showing a causal relationship between the two?
So far, there have been hundreds of genes that have been associated with autism, and it appears to most that there are combinations of genes that seem to confer a risk for developing autism. All the people who might have one particular gene don't necessarily develop autism, so there's something about the way that gene expresses itself and interacts with the environment. At this point, at best, we know of about 25% of cases of autism have some kind of genetic predisposition. The most common one is Fragile X, that people with Fragile X have a more common incidence of autism, but all people with Fragile X don't have autism. There are several others like tuberous sclerosis or P10 or Downs or several others, but again, it's not, if you have that gene, you definitely have autism. It appears these multiple genes interact in ways with each other's in the environment that creates a risk for autism. So that can help people know what the genetic component was, especially if people are thinking of having a family, other people from that person with that genetic risk, to know whether other people may be at some risk if it's a particularly, we would call penetrant gene, or a gene that is more commonly associated if it's a rare gene, or a gene that wasn't carried by the family members, then it's not as likely to be passed on.
Thank you. Another associative question. You mentioned that with autism, there's higher incidence of seizures, GI problems, and I wondered, is there any cause and effect evidence, or are they just that certain clusters of symptomology with, for example, seizures and GI problems are associated with autism, rather than any, for example, neurologic principle that correlates in terms of causation?
Yeah, it's a tough question, and people haven't been able to fully show how these things are associated with autism in a cause and effect way or back. So it used to be thought that the GI problems in autism were not necessarily related or didn't have meaning. The gut has lots of serotonin receptors. The brain has lots of serotonin receptors. The gut and the brain form at about the same time embryologically. So increasingly people are saying there is a gut-brain connection, and there is a relationship between what's happening in the gut and what's happening with autism. But no one has said they're directly correlated, other than they just are associated with each other, but not cause and effect. The seizure disorder doesn't occur with most people, but there are brain changes in people who have autism, and there's some early evidence that says maybe those brain changes show up early and could be predictive of the later development of a seizure. It's not hard evidence yet, but one neurologist I know in Sacramento puts almost all of his patients on Depakote as a way of preventing the later development of seizures, and he says none of his patients have developed seizures when 30% should have. So it's not a science at this point, but there are people that are recognizing benefits to seeing the associations.
Thank you. The audience in the auditorium, there's a question. The young lady in the back, could you hand her the microphone, please?
Hi, I actually have several questions for some of the different speakers. My name is Connie Boyer. I'm with the Autism Society, San Francisco Bay Area. I guess the first one is for Tim. If you have an adult receiving both SSI and then getting or starting to get retirement benefits from their parents, I've heard that if those benefits become high enough, then it will kick them off SSI. And I also heard that there's such a thing as the Pickle Amendment, so that they don't lose their Medi-Cal and lose their IHSS. So I'm just wondering, is that benefit at risk for the future in terms of losing Medi-Cal? Is the Pickle Amendment appropriate, and how does that work?
I'm
We're not really sure what you mean by a pickle amendment.
Well, in other words,
I can tell you what will happen in terms of the SSI itself is that the benefits received from as a disabled adult child will count against the SSI on a one-for-one basis after a $20. At the discount $20, and then after that, $1 for $1 will reduce it. And so, if your SSI amount in California $850, and you get more than $870, then that'll eliminate you from SSI. And if your SSI amount is less than zero, now if it's zero, you still get you do still get Medi-Cal, but if it goes to less than 0, you can then it'll stop, and your Medi-Cal can eventually be cut off. I'm not as up on the Medi-Cal rules, but I do know that there's an extended period that you're eligible for Medi-Cal after you're cut off of SSI. And also, if you're receiving the benefits from being on the disabled adult child, you should then eventually get onto Medicare. But exactly what happens with the health, I'm not as clear on.
Because a number of our adults are getting in-home support services, and that's contingent on getting SSI and Medi-Cal, and so that's the concern. And so I just wondered where we're going in that, because they've been slowly whittling away services.
Yeah, I don't know what'll happen there. That's not because I haven't worked with that for a while, but I do know that a lot of people do want at least some SSI, so they qualify for in-home support services, and I'm not sure what happens.
Okay, my next question, I guess, is for Dr. Kimball regarding crisis intervention services. We did an informal survey a few years ago about what were the crisis services for regional centers, and a number of them have these crisis intervention teams. The problem is that some of the regional centers only have those crisis intervention teams handling crises from 8 to 5, and then afterwards they do the phone call thing. And I just wondered, that often doesn't meet the person's needs, as you know. I just wondered if there's any hope in the future to, as far as what can be done for crisis intervention services that are more, that can solve the problem a little better, other than just calling the police. And also if crisis homes, which seem to be very in short supply, if anybody's addressing those.
Yeah, great question. Just in terms of my work with CBIM, when I started in serving North Bay Regional Center 4 years ago, since then we've had 3 more critical intervention services open up for 3 more regional centers, and I think there's 3 more online for us coming in as a vendor to provide 24/7, 365, round the clock. We go on site, we're by phone, we go in any environment. So the point being to your question is, just in this example, we're seeing increased need for services 24/7, and also for the budget to provide for that. What I said earlier is the best time to stabilize someone is to prevent a crisis rather than have people go into crisis. So our program design is trying to be very preventative. We actually prefer it in our services when a service coordinator from whichever regional center we serve contacts us often weeks or months ahead of a massive transition. If someone's aging out of school, they're changing a day program, whatever the change is, we prefer that they contact us ahead of time to get ahead of it and create the supports in place to not go into crisis. But the sad truth of the matter is we're getting more and more demands for our services in all of the regional centers through the state of California, and the program design of ours is proactive, not just reactive. And we also have follow-up. So we serve from 3 to 6 months, not just one night on a hotline call. Back to your point, what can we do with the whole entire circle of support to, give away and impart stabilizing tools and strategies and techniques that we know work, so that people don't call 911, and it's very traumatic for all parties involved. So in that way, I think we'd like to create enough education that, it's a bad business model to say you want, built-in obsolescence for our services. We'd rather, teach and train people to do what's necessary on the front end than get the hotline calls on the back end.
Are you getting the budget to do that? I guess I'm speaking as an advocate now.
What's sad, to be quite honest, if you look at numbers and dollars over years, is typically the budgets for whether it's county mental health or developmental disability services have traditionally gone down, but budgets for crisis intervention has gone up. And what we're saying, because our program design started to get proactive, not just reactive, was in response to that.
And then thank you. I have one other final question regarding, I think it was Pilar who mentioned about the regional center's responsibility to give to share with the families who the providers are, and if they're being told that they're not enough providers or they don't have the providers, what is the parent's recourse? Because that frequently happens. I hear it a lot from people who call for information and referral, and they're told by their service coordinator, well, I'm sorry, we don't have any crisis homes, or we don't have any group homes nearby, you'll have to go 150 miles away, or no, here's a list of behaviorists, especially for behaviorists for adults, which seem to be in very short supply. So who can they turn to when they are told by the regional center, no, we just don't have the vendors?
Sure, that's a great question, and one that comes up all the time. I think there's two answers. One is what you can do in an individual basis. So if a client's IPP says that they should be getting, 4 hours a week of, I'm just going to put CBAM as an example, of CBAM services, and that's in their IPP, and then they're not getting it, and the social worker says, well, CBAM is full, so you don't get those 4 hours. The regional center at that time is actually violating an IPP, which is a contract, so you can actually file a complaint against the regional center. If the regional center, if you ask your regional center for extra services and they're saying, and they're not in your IPP, and you would like to have them, and they're saying, well, we just don't have anyone, then that's a denial of services, and you have a right to receive a notice of action and then file an appeal. And so the appeal process is the same thing as the appeal for eligibility. So there are two different mechanisms in that way. So those are very kind of direct action. I think the other solution, more long-term, is to really, advocate as parent groups for the regional center. If there's a parent that's not getting certain services or a consumer, I'm sure there's more in that regional center. So getting involved with your regional center, going to board meetings, all of the regional center board meetings are open to the public, and saying, we need you to put more resources into crisis interventions, into, providers like CBAM, so they can hire more people, because a lot of families need this. Or, we need ABA therapy for children that don't have autism and is not covered by Medi-Cal. We need you to come up with those providers. And so putting that, those advocacy, that advocacy hat on, and trying to work in a more systemic way as parents and family.
And one thing I'll just add, just to note, is CBAM is never full. We take on every client that's ever referred to us 24/7, 365. We don't really have a cap, essentially. We always serve, just to say. The other, what we're noticing is we are often referred when there aren't other services, and we come into a gap of services. We're trying to find interim supports that we can apply ourselves, ABA tools, psychological sensibilities, assessments, until we get the long-term supports in place. So there's times CBAMs come in for 3 to 6 months until we can get long-term providers to really provide the ongoing needs to maintain stability. So we're seeing an escalation in our services in that way, because there is a need for resource development. And then I meet regularly with the Director of Client Services of North Bay Regional Center, and then I feed back to North Bay, you need to develop these resources because we're getting all these calls. So I'm actually a conduit of identifying resource development that typically ends up in RFPs, requests for proposals, for further services 1, 2, 3, 5 years out. So we now have a service in North Bay we didn't have when I started CBAM 4 years ago. And I'm trying to be a conduit for that, so that it's not just crisis. We get the long-term supports we need.
So you accept courtesy vendorization, and they will give them to you?
Yes. Mm-hmm.
Let me just say something about your IHSS question. There is no correlation between IHSS and SSI. IHSS is a state program. The recipient could be on county welfare, for example, or may need IHSS for less than a year, where SSI is only for more than a year. I don't see any correlation. I mean, if you have a specific question, regarding the client's specific facts, you can call People with Disabilities Foundation. We do a lot of Social Security and SSI there. There really is just no correlation for not being eligible for one or the other, if you're on or off one or the other. One's state, one's federal, and one is not dependent on the other.
And Stephen, I know we're almost out of time. I wanted to go back to Dr. Hendren about the seizures, just an exploration, not here to fully explore, but I'm curious if you're seeing a relationship in the seizures related to metabolic issues, where people are actually having what is not actually epilepsy, but is almost like a grand mal seizure from stress, vasovagal, vagus nerve, a whole kind of cluster of phenomenon that are also sometimes related to blood sugar levels, because we've gotten some crisis calls of individuals, and when we find out they weren't drinking water, they weren't eating protein, they were in a stressful social environment, they're on the spectrum, there was this cluster, they had full seizures, they got assessed, were ruled out for epilepsy, but when we looked at the combination of the dehydration, the metabolic, and the vasovagal vagus nerve, there was a whole presentation of a seizure. And I'm not a doctor, but I saw it from a crisis point of view.
I think that's a good point. The 30% is epilepsy, grand mal seizures. So it's not these other kinds, but it's not unusual, as you're suggesting, to see that. And it's really important that people get an evaluation. And I find most neurologists, after the first seizure, won't treat it and will try and do more of a workup. And then it's after the second or third that they do.
Great. Thank you.
Thanks. I'm going to have to leave. I'm sorry.
I have one quick seizure question. The doctor in Sacramento, did he keep the people on the Depakote so you don't know if they would have had seizures again, or was this for a short period of time and then they went off?
They were people that he felt in adolescence or early adolescence were at risk of developing seizures, sometimes because they had epileptiform abnormalities in their EEG or other abnormalities, and he put them on it and kept them on it till they were about 25. There's a lot of risk of being on Depakote for that long. He felt it was warranted, and I don't think all doctors would, but he had a good track record. And thanks.